Well, hello, friends. Welcome to Investment Immigration Conversations. I'm your host, Carolyn Lee, principal and founder of Carolyn Lee PLLC, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. Well, I'm going to confess I'm a little nervous today because today we're discussing a topic that is so topical and incredibly near and dear to my heart. And I think this is really at the heart of the best of the EB-5 Reform and Integrity Act of 2022. It's sort of the soul of it. And what makes us all feel so optimistic about the program and what it's about, right? We're talking about subparagraph M. M as in Mary. 203B5 subparagraph M. And it is very topical because just last week, USCIS began issuing these 180-day notices pursuant to subparagraph M en masse. We had been seeing the notices trickle out here and there. The format has changed somewhat, and these notices were issued by the hundreds, it seems, in the last couple of weeks. So this is very much on the top of minds for not just our many, many clients engaging us for their subparagraph M related issues, but for the entire ecosystem. Okay. All right, so I'm going to try to proceed with a bit more structure than we normally would in our free-flowing conversations. I want to talk a little bit about the context and the history of subparagraph M. I want to then go into talking a little bit about the structure of the statute itself, the subparagraph M itself. I want to talk then about these notices, the notices of regional center terminations, kind of look at the options presented. And we'll go then into some Q&A. All right, how about that? A little bit about the context. So the context is, we have to start with Senator Leahy and the Vermont Regional Center and the Jay Peak debacle. The Vermont Regional Center was one of these, hallowed presences in the industry. Not only was it among the oldest regional centers, but it was also state-run, state-sponsored, and it had the historic support of Senator Patrick Leahy from Vermont. And so it was indeed a shock to us all when the Jay Peak projects under the Vermont Regional Center sponsorship started to unravel due to fraud. And it affected a number of projects managed by Jay Peak, which were under the sponsorship of or affiliation of the Vermont Regional Center. What happened with that, there are many, obviously, aspects to that story. What's relevant for us was that the regional center was terminated, and that termination affected not only the new commercial enterprises controlled by Jay Peak, but also completely unrelated new commercial enterprises, because under state sponsorship, the new commercial enterprises could affiliate independently of the other new commercial enterprises. And of course, the good faith, innocent investors in all of those new commercial enterprises, including the Jay Peak new commercial enterprises. And I can only imagine what this, how this was absorbed by Senator Leahy and his staff, who had been such a staunch and steadfast champion of the EB-5 program. I imagine it was devastating. And subparagraph M is what I like to think, and I believe this is so, an effort by Senator Leahy and his staff to take something that was really the worst of the program, that these frauds can exist and that they can affect these innocent investors and their families, and to convert that into something good. And in fact, what I think is the best of the EB-5 program. So I just want to take a moment to express my gratitude to Senator Leahy and his wonderful staffer who worked on subparagraph M with IIUSA, a team that I was very proud to be a participant of, and in particular, working on this rescue provision in the RIA. Okay. The structure of subparagraph M, if I may say so, it is a thing of beauty. There is a logic to it, not perfect, but there is an internal logic to it. And I'm just going to try to summarize it a little bit. The first section is about termination, okay, and the impact of termination of regional centers and new commercial enterprises and JCEs on investors. And it starts out by saying the effect is that the petitions and the conditional permanent residencies of affected investors will remain valid and they will continue to be authorized. Second thing, clause 1, Romanet 1 of subparagraph M says, is that USCIS will begin notifying the affected investors. Okay, and those are the notices that we're all seeing. So it's a curious thing. It says all the investors' petitions and CPR statuses will remain valid. The second clause, clause 2, though, says that that petition and that status will be terminated in 180 days of the notice, unless the investor takes certain specific actions enumerated under clause 2. Where there is a termination of the regional center, the investor, or the first action that can be taken within the 180 days, is that the new commercial enterprise can leave the terminated regional center and reassociate with a regional center in good standing, what we've begun to call RCGS, Regional Center in Good Standing. The second thing that can be done is there's an investor action. An investor, an affected investor, can make a new qualifying investment in a new commercial enterprise, or NNCE. We're not going to talk about the process and the remedies available in the event of new commercial enterprise debarment. That's to come. There are greater complexities there, and we haven't seen those notices yet. So that's clause 2. Clause 3 talks about the process, okay? And that's what's laid out in these 3 options we see in the regional center termination notices. And it's about amendments and about notification. So if the investor believes upon receiving this notice that he or she continues to remain eligible for EB-5 benefits, they can simply notify the USCIS of that within the 180 days. Or the affected investor can amend his or her petition. And he or she can amend the petition by saying, we're going to take this NCE and reaffiliate that NCE. My NCE is going to reaffiliate with an RCGS, regional center in good standing, or an amendment. The investor can file an amendment saying, I am going to make another qualifying investment in a new commercial enterprise. Okay. The subsequent sections talk about what I call the basket of goodies, the good things, the remedies, the rescue provisions that come into play for these affected good faith investors who've had no participation in the reasons leading to these sanctions. And they are removal of conditions after 2 years of making a qualified investment, rather than after 2 years of conditional permanent residency in the normal statutory scheme. Also, priority date retention and age out prevention, protection of the kids from aging out. Huge. Okay, so that's in a nutshell the structure of subparagraph M. Now let's look at these notices that have been issuing. Okay, and I've got to put on my reading glasses because the print is teeny tiny. And I do love that we're saving paper. Let's save our trees, folks. All right, so we're observing that these notices are issuing, it seems like across the board, regardless of what status the investor may be in, as long as there's been a termination of the regional center associated with that investor's petition. Okay, so this is from a notice of regional center termination on a 526E, a post RIA filed 526E that remains pending. And there are, there's a matrix of different scenarios here. And there's an important distinction to be made between pre-RIA investors and post-RIA investors for reasons that we'll try to get into a little bit in the Q&As. So I'm going to focus on the 3 options presented in this notice. All right. So the first option is about the notice, the notification that I continue to meet eligibility requirements. Okay. So it says, respond to this notice to demonstrate that your petition continues to meet the eligibility requirements, notwithstanding the termination of your regional center. In general, you may continue to be eligible if your capital remained invested for at least 2 years and satisfied the job creation requirements before termination of your regional center. There's no need to submit evidence already in the record. Now this, importantly, as I mentioned, is a post-RIA investor. So there is a different standard with respect to the sustainment duration. Pre-RIA investors must sustain their investment through the 2 years, through to the end of the 2 years of conditional residency. Under the RIA, as we all know, it's the 2 years on the front end, okay? And that's what this language is getting at. Option 2, file a Form I-526 amendment to demonstrate that your new commercial enterprise has associated with an approved regional center, regardless of the approved regional center's boundaries. Again, thank you, RIA in subparagraph M. When a new commercial enterprise affiliates with an RCGS, regional center in good standing, that regional center does not have to have the same geographical bounds as the original. Your Form I-526E amendment must be filed in accordance with the form instructions, including payment of all applicable fees. The new regional center should file a Form I-956F because the view is that for post-RIA investors, their 526E must be associated with a pending or approved I-956F. This is very important and very interesting. Okay? And very logical as well, I would say. I do want to take a pause here. Perhaps this is the moment to really quickly share, do a little screen share if I can manage, and show you that the Form I-526E contemplates this reaffiliation, reassociation with an RCGS scenario. So this is the 526E, and you see that at the very start, part 1, we've got a checkbox that says this petition is an initial petition. This petition is being filed to amend a previously filed petition. And it also has a section to denote the reasons for this amendment: termination of the regional center, notice date of termination, or NCE JCE debarment. All right. So there's been some, a forethought to the implementation of subparagraph M that we see already. Okay. Option 3. So the second option was about the new commercial enterprise affiliating with an RCGS. Option 3. Respond to this notice if you intend to amend your petition and demonstrate that you have made a qualifying investment in another new commercial enterprise. If you choose this option, please send your response via email or mail with everything that establishes that you've made a qualified investment. All right, and that maps to the statute that we just went over that allows an investor associated with the terminated regional center to make a new qualifying EB-5 investment. Okay, so that is a summary of the 3 options presented in the notices of termination. Many interesting things there. I think we can also pause a moment and talk about a little bit about the distinctions that we're seeing in the notices our clients are receiving, where they are at the back end of their immigration process in the 829 stage, where they're already conditional permanent residents. And in those cases, the options are a little bit different. So for those clients, for those investors, there's no 526E associated with their case. These are pre-RIA investors, and so they will have a 526. And so for option 2, there is no mention of a need for an association with a pending or approved 956F. Makes sense. All right, so that's one of the key distinctions there with pre and post RIA affected investors. Let's drill down into some of the Q&As and get into that. And feel free to post some questions in the Q&A section as well, okay? All right, let's get into this. All right. Does M apply to pre-RIA investors? Yes, clearly. Because for one thing, we're seeing the notices issuing to pre-RIA investors. And secondly, it is so stated expressly in the EB-5 Q&As, which I commend everyone to look to, for especially for subparagraph M guidance and for many, many other things, including sustainment. How do I establish maintaining eligibility if I'm a pre-RIA investor? This is meaty. In general, the pre-RIA investor is going to maintain eligibility if you're eligible, if you've met the eligibility requirements per the pre-RIA requirements. And that is also very clear. It's in a footnote in the options. It is in the Q&A. It is in the RIA itself. The law in place at the time of filing your 526 is the law that will apply here as well in terms of eligibility. So it's about the eligibility requirements in place for a pre-RIA investor, and it's about the eligibility requirements that are different for post-RIA investors. Just an example of a difference, the requirement for an I-956F affiliation with the associated 526E, that is a requirement applicable to post-RIA investors, but not to pre-RIA investors. Here's an important point. The EB-5 Q&As say, if you establish eligibility, if there's been project completion or sufficient jobs created and you've sustained for the required period applicable to you, and your regional center has been terminated and you're getting this notice, you may establish eligibility based on your meeting the eligibility requirements, notwithstanding the fact that your regional center has been terminated. This is big. What does this mean? It means you may not have to file an amendment. It means that you can notify the USCIS that you continue to maintain the, you continue to meet the eligibility requirements, option 1. Now, I'm going to take a moment right here to say this webcast is informational and it is absolutely not advice in this incredibly enlivening, incredibly important, incredibly complex and novel area of EB-5. So not saying that it's okay, but that USCIS is suggesting that you may continue to satisfy eligibility requirements as is if you, if the project is completed, everything is on track, jobs have been created, and you have met the investment requirements. And that's a lot. There's a lot by way of our eligibility requirements, aren't there? Okay. How do I continue to be eligible if I'm a post-RIA investor? Okay, kind of the same. Your eligibility requirements applicable to post-RIA, including our slightly different job creation formula, the 956F requirements, our different lawful source of funds requirements, etc. We have different eligibility criteria. Got to continue to meet them. Okay, but if you do, you may be spared the need to reassociate your NCE with an RCGS or to make a new qualifying investment. To drive the point home, service guidance also says for both pre-RIA and post-RIA investors, if there's been project failure or insufficient jobs, you may want to avail yourself of the protections under subparagraph M by filing an amendment and taking one of those actions. Affiliating with a new regional center, making a new qualifying investment in the event of regional center terminations. Here's a great one. What if I don't know whether I continue to meet eligibility requirements because, for example, I'm a conditional permanent resident and it's not time to file my I-829 yet. And that's when I would establish that I'm eligible for 829 approval. What do? Well, we have a lacuna here. I don't believe that the guidance we have answers this question. However, do you just ignore and not respond to the 180-day notice? No, I don't think that's the approach there. Want to respond timely within the 180 days to the notice. But how can you answer whether you continue to meet the eligibility requirements? And so I think putting into the record that statement, that concept, that it's not ripe for me to affirmatively represent that I continue to make the eligibility requirements. And it makes sense because you're not required to establish eligibility at that stage, at this stage for a conditional permanent resident. I would also add that the language in M allows reprieve in terms of deadlines for response. And that plus the fact that I do commend the agency and the chief of IPO for the breadth of generosity, of liberality in interpreting M to give effect to congressional intent, in filling the gaps that will exist, because we're talking about language, and language has gaps. And moreover, this was stitched from whole cloth, folks. That we are seeing every intent and every way possible consistent with the framework of the statute, not straining the bounds of the language in the statute to give effect to congressional intent to protect investors. So relying on that, I think one can also say in that scenario, if you're CPR and it's not yet ripe for you to file your 829, that this invocation of the extension of timeframes is also perhaps appropriate, and hopefully will be accepted in the spirit that we're seeing so far, thankfully. I'm a post-RIA investor. What happens to my associated 956F if my regional center is terminated? Well, that's also clear. The 956F will fall. If it's pending, it will be denied. If it's approved, it will be revoked. And thus the basis for the associated 526E will also fall. What if my project failed, but my regional center has not been terminated and my new commercial enterprise has not been debarred? Can I file an amendment and retain my priority date and get the basket of goodies? The answer is no. These subparagraph M remedies are triggered upon the notification, the 180-day notices that USCIS is issuing. So if there's been some other kind of problem, failure, sufficient job creation, etc., that by itself is not sufficient to trigger these remedies. Okay, there are other fixes, and I believe I've spoken on those. Can I request that USCIS terminate my regional center or debar my NCE? The answer here is also no. The service has said, no, you cannot ask us to take these actions. We will take them sua sponte ourselves. The exception is regional centers can seek to voluntarily withdraw participation from the EB-5 regional center program. That is so. And when a regional center does so, their associated investors are also receiving these notices of termination. Okay. How long do I have to respond to a notice of regional center termination or debarment? Very clear. It's statutorily, it's 180 days. The notices give 183 where the notices have been sent by mail, 194 days if the recipient is outside the US. Similarly for your other notices like requests for evidence. All right. I think I hit the questions that I thought were important to cover. We have quite a few questions, and just going to take a couple before concluding for the day. Have you been seeing this for rural centers as well? There is no distinction between a rural regional center and others. So firstly, whether or not a project is in a rural TEA or high employment TEA is it's not going to turn on the regional center. A regional center can sponsor rural projects, non-rural projects, et cetera. There are some that, at least thus far, have only done one or the other, but they're not required to. So it's in terms of the, that the TEA designation, it's project by project. And so there isn't going to be, in terms of, reason for terminating, a distinction based on whether they have rural projects or not. Have you been seeing this for post-RIA? Yes. Are there specific types of regional centers that you have been seeing this happen to? If I can feel for the question, it's the regional centers that have been problematic, right? That seem like there's some sanction that may underlie that termination, as well as perfectly great regional centers that have done fantastic work for immigrant investors that have sought to unwind, that are not operating post-RIA, that have voluntarily withdrawn from the program. So I don't think that one can look at whether or not a regional center has been terminated and these notices issued to sort of go, you're not one of the good ones. And in that vein, it's very similar to before all of this. Regional center terminations have been a thing, and regional centers have been seeking voluntary termination well before this. And so when you look at the list of terminated regional centers, included among there will be the best and the oldest regional centers operating, because some of them have withdrawn from the program for various reasons. Here's a great question. Pre-RIA, so this is the scenario where I assume the regional center termination notice has issued. Pre-RIA investors, capital redeployed, completed job creation, but redeploying to finish the sustainment requirement. Okay, so that is a scenario where I would say the eligibility requirements have not yet been established. For pre-RIA, okay, here's a question. So for pre-RIA investors who have conditional green cards and have received their funds back, presumably consistent with their with the end of their sustainment periods, right? With their sustainment requirement being satisfied, what are their next steps? Well, this is where your counsel comes in. Okay, they're going to have to help you determine where you are here, which option 1, 2, or 3. And the question, just to be a little bit more helpful, the answer is going to turn on, to start at least, whether you can claim that you have met the eligibility requirements. This is also helpful. What does new qualifying investment mean? Do investors need to invest the full amount again? If you associate with an existing NCE, the funds can just move to an existing NCE. Don't know what. So an important principle here is that the requirements in place at the time of your initial 526 filing are the requirements for eligibility that apply to you. Not you specifically, but you generally. So if you are a pre-RIA investor, then your requirements are, I've got to make an investment in a in a TEA to qualify for $500,000 investment versus $1 million. I have to, of course, make sure, you know, your source of funds are lawful. It's mainly about, you know, just as a starting point, the level of investment. This was a key question, and that question's been resolved. For pre-RIA investors, a qualifying investment is $500,000 and not the post-RIA level of $800,000. And that is clarified in a footnote 2, associated with a new investment option, a qualifying investment option. And it's important to note, and you know, I was being a tiny bit cheeky before, but establishing eligibility is simply, you know, notifying that I continue to meet the eligibility requirements. This is not a simple, oh yes, as these questions are showing us, whether or not you continue to meet the eligibility requirements. And so you tick option 1 versus 2 or 3 is a very momentous decision, especially because the service has said to the question, could I later amend my answer, you know, like change my mind? The service has said no. So establishing eligibility is an important consideration. I think that there's also a very important nuanced point here, which is the amendments. It may be the amendments that trigger the basket of goodies, these very special remedies. Filing a notification only may not. Okay. What about pre-RIA investors who have not landed or started their CPR due to visa retrogression? Same thing. Don't, in a certain respect, it's, you know, following the logic is, I think, going to be helpful. So you're not in conditional permanent residency status. This is the scenario also that we covered a bit ago. So this scenario is, I've gotten my 526 or 526C approved. It's 526, right? This is pre-RIA investor. 526 approved. I'm waiting for my priority date to be current, for an interview to come in, etc. This is actually an interesting point in terms of which eligibility requirements apply, because if the 526 has been approved, arguably you've established that the 526 eligibility requirements have been met. However, we know that that is not the end of the story. What if, because the 526 is prospective, it's about future job creation, and that is all the adjudication resolves, is that you have shown by preponderance of the evidence that you will create enough jobs within the required time period. But the pudding is in the 829. So you're not going to know that you have established eligibility until that stage. And so this is the quandary that we covered with the Q&A on that point earlier. You want to respond. I think generally, again, this is not advice, but we believe that the notices should be timely responded to. In terms of what you say by way of eligibility or choosing an amendment, these are important decisions, and I think they're also tactical as well. So you need to get with counsel on these questions. Is there any difference? Oh, gosh. Lots and lots of questions. Is there any difference? This is a good question. Is there any difference between whether the regional center was terminated on fraud basis or administrative non-compliance or even voluntarily withdrawal, right? I don't think so. the options map to the statute. And so regardless, so think about this. My regional center has been voluntarily terminated after years and years of doing fantastic work. Do I still, am I still able to avail myself of these very special remedies? Arguably, yes. Arguably, yes. I'm just going to take one more question because they continue to stream in. Let me see if I can find the one that I mentally put a pin on. Yeah, I'll close with this one. My 829 has been approved and my family and I have 10-year LPRs issued. Does this impact me? I have yet to receive my investment back. Is there any danger of my getting my investment back due to the action of USCIS? So, yeah, so we actually have one of these as well. This one, I haven't fully baked out the response strategy here, but let's just kind of present the kind of the quirk of this situation, because kind of like our earlier scenario of the questions not sort of being ripe for a good response because we're just not in a position to express our eligibility. There's nothing to adjudicate further. We're done. We're out. The 829 has been approved. And so interestingly, I think the way that this should resolve is respond to the notice and that all is well, for a number of reasons. But I will note that there is some, sort of ominous language in the notices that say, we have the authority to deny, to terminate, to revoke approvals. So, you think, wow, 829 approval, I'm at the end. And yet there is this language. So I think you don't want to dismiss this. And at minimum, to start, baseline, take it seriously, do not ignore, respond timely. I'm going to end with that. I hope this has been helpful. And we know that we're going to continue to have these conversations about subparagraph M as we continue to advise our investors, investor groups, regional centers, new commercial enterprises make their way through this. So wishing everyone out there luck, and we'll see you next time.